Good morning. The advocates, those who are interested in understanding the criminal trial, how witnesses were examined, and what witnesses deposing about what fact, what all are the documents are being filed. Apart from that, some ratio is there. But if you go through the entirety of judgment, you can understand how this judgment was delivered by Justice Pardiwala, trying to explain everything so that the aspiring advocates preparing for examination and criminal lawyers should understand the entire procedures. The judgment is AR 2023 Supreme Court 4097. AR 2023 Supreme Court 4097. Mukesh Singh versus State. The ratio is simple. Section 54A, Evidence Act 9. Test Identification Period, TIP. Refusal by accused. Compelled attendance of an accused at a test identification period is comparatively remote to the final evidence and cannot be said by itself to furnish any positive violation evidentiary act so as to violate of Article 23. By virtue of Section 54A CRPC, an accused is under an obligation to stand for identification period. If the same results in getting from accused evidence which cannot be procured save through positive violational act on his part, Article 23 will be attracted. However, if that evidence can be procured without any positive violational evidentiary act on the part of accused, Article 23 will have no application. Then they say Section 9, Test Identification Period Value, Section 9 of Indian Evidence Act. Substantive evidence is evidence of identification in court, and test identification period provides corroboration to identification of witness in court. If required, weight to be attached to evidence of identification in court which is not preceded by test identification period is a matter for court fact to examine. So they say even though they know the proper test identification period before trial was conducted, the court can still appreciate the value of witnesses being identifying the accused during trial. This is what ratio. Then they say conduct of accused in pointing out to the police officer the place where he had concealed the weapon of offense would be admissible as conduct under Section 8. This is what the ratio they say. So, Section 8, 3, 9, 27 and 54 Evidence Act and 54A of the Criminal Procedure Code were deeply discussed. That is not important. The important the paragraph is paragraph 7, where public witnesses, eyewitnesses were clearly tabulated and giving particulars. Which witness speaks about what fact. Then they said medical evidence witnesses, then police official witnesses, then they say also what all are the documents marked, why these documents are important. This tabular may help you if you go through the entirety slowly, once, twice, thrice. This will definitely help you in writing your examination. And so far other questions of Section 8 and other things are concerned, you have to deeply go through the judgment. This is case of Mukesh Singh versus State NCT Delhi. I think you understand the value of test identification period after the judgment. The judgment was headed by Justice M.N. Sundaresh and Justice J.B. Bardiwala. The judgment was delivered by Bardiwala with the concurrence of Justice M.N. Sundaresh. All these things should be, you have to understand. See, so many things have been stated, paraways about the witnesses' evidences. So many. Finally, they say, since for the past so many years, the young boys are inside, 16 years, they still, the court did not set aside the conviction. They only recommended a competent authority of state for premature release. Only to that extent the relief was granted, and this is what the judgment. So you must go through the judgment, the person who is preparing for examinations. Best wishes.